Is a will enough or do I need a trust? That's a question that I get asked all the time or that I hear people talking about. Well, a lawyer's favorite answer is it depends. And that's the answer for here as well. It depends on the type of assets that you have. So let's talk about it and let's use some examples to make sure you understand the difference. If you have real property, such as land, a home, mineral interest, you likely need a trust. And why would that be? Well, while you're alive and well, and if you own real property, let's say a house, if you want to sell the house, you just go and sign the deed and you sell the house. If you become incapacitated, let's say you have a mental condition and you are unable to sign the deed, you either have a power of attorney in place, a person you designated to act on your behalf, and they can sign your name by their name as your power of attorney, or if you don't have a power of attorney in place, an adult guardianship proceeding will have to be filed, someone will go in front of a judge, get the authorization to sign documents on your behalf, and sell the house. So what happens if you die, or when you die, better said? Who has the authority to sign that deed and sell the house or the land, the mineral interests? Well, if all you have is a will and no other way to avoid probate, a loved one, a beneficiary, someone in your family will likely have to go through the court system, file for probate, and through the probate process, they will be appointed as personal representative or executor and then have the authority to sign the deed and sell the house or distribute it to whomever is entitled to it. If you have a trust, on the other hand, and you designate a successor trustee, that successor trustee will have the authority to sign the deed and sell the house after your death, as long as the house is placed in the trust through a deed. I hope this makes sense. Now let's talk about why sometimes you don't need a trust, why a will is enough, or maybe no will at all. Again, it depends. It depends on the type of assets you have. It depends on your beneficiaries. If you don't have real property, let's say you're renting, or let's say you live in a nursing community or 55 plus community, then you don't have real property, so we don't need to worry about who has the authority to sign the deed and sell that property. So let's say all you have is bank accounts, maybe a life insurance, retirement, some investments. If you have adult beneficiaries who are responsible, you may choose to have them listed as beneficiaries to these accounts. Make sure you have primary and secondary, and that's that. When you pass, those assets will go directly to the listed beneficiaries. But what about if you have special needs kids, or your beneficiaries are adults but they are not responsible? They need some terms and conditions before receiving that money. Or you have minor kids. You don't want minor kids to inherit not only real property but financial assets, a lot of money at one time. That's another reason why you would need a trust even if you don't have real property. You can list the trust as a beneficiary to your retirement, your life insurance, to your bank accounts. And that trustee, that successor trustee, the person you nominate to be in charge after you die, will follow the terms of the trust. In the trust, you can provide for a gradual distribution for your minor kids, or you can provide for a special needs trust if you have special needs beneficiaries. As a quick recap, do you need a trust or is a will enough? It depends. Do you have real property? If you do, you likely need a trust. There are some alternatives to a trust, such as a transfer on death deed. Sometimes people use joint tenancy. They add someone to the deed. Not a good idea. Sometimes people use LLCs. Again, there are some alternatives. Just make sure you fully understand the pros and cons to each of these alternative methods. If you don't have real property, you may need a trust if your beneficiaries are not responsible adults, if you have minor kids, if you need to plan a little more on how and where the money are to be distributed. It is very important to mention that if you only have a will and you have real property, land, mineral interest, your house, that will have to be probated. It will have to go through the court system in order to be administered. A personal representative or an executive does not automatically step into the role. They have to be officially appointed through the court system. A judge has to sign that order. On the other hand, a successor trustee automatically steps into the role and no court involvement is required. So while a will may sound like a good idea now because it's less expensive than a trust, have in mind that your family will likely have to go through a public process through probate. I hope this video helped answer some questions. I hope you can now understand the difference between a will and a trust, at least a little bit, at least enough to get you started, to ask questions, to do some research. If you want to learn more about it, visit one of our educational events at the Well. I'll have a poster at the end of this video, or visit our website for more information. Watch our other educational videos, like our Facebook page, and please email me if you have any questions. Thank you for watching.